I wish to have the bill shortly entitled the Bail Amendment Bill 2017 read a second time. This, of course, Mr. Speaker, is with your leave. This bill was first read in this Honorable House on the 23rd of May, 2017, and it was subsequently circulated for comments to various stakeholders. I am advised, Mr. Speaker, that there have been some comments from the general public which I believe would be reflected in the presentations of the members in the House and which would have been considered and incorporated in the adjustments that are going to be made to the bill at committee stage. We intend, Mr. Speaker, that the current bill before us is to amend the Bail Act 2012, in some four ways. Firstly, the bill would further empower the court in the exercise of its discretion to grant bail, the option of an additional condition to be considered in the granting of bail. That is, for someone who is accused of an offense to have to wear a monitoring device or an ankle bracelet. Secondly, Mr. Speaker, we envisage the bill to be amended by restricting the granting of bail for someone charged for manslaughter or murder by increasing the threshold of the burden of proof to the standard of beyond a reasonable doubt, so that a court would still have its discretion, but that the standard for one to be considered for bail should be, the threshold should rise. Similarly, Mr. Speaker, where a person who has been convicted with a firearm offense is again charged with that type of offense, a firearm offense, within a period of 10 years, then the threshold will also change, will also be changed as well. And the fourth proposed change, Mr. Speaker, would involve increasing the list of offenses for which the application for bail would only be entertained in the High Court, by the High Court. Mr. Speaker, we are very conscious that the Constitution of St. Kitts and Nevis lays out in Chapter 2 the protection of fundamental rights and freedoms of our citizens, one of which is set out in Section 5, which is the right to personal liberty. It provides that a person shall not be deprived of his personal liberty save as may be authorized by law, that is, by the court, in a number of cases. And some of these cases include in the execution of a sentence or an order of a court in respect of a criminal conviction. Mr. Speaker, the genesis of the bill before us emerged from the initiatives of the Royal St. Christopher and Nevis Police Force, which towards the end of last year made a number of recommendations for changes to the legal framework relating to criminal justice in the Federation. These recommendations to amend the laws would seek to create more efficiency in the criminal justice sphere, further empower law enforcement, and strengthen the deterrent effect to criminality. One such recommendation was the proposed amendment to the Bail Act of 2012, which would entail measures to address, to reduce, to prevent offenses by persons charged with capital offenses involving firearms. It was observed that a number of persons charged with capital offenses, for instance, involving firearms, have, whilst out on bail, committed other capital offenses. In that connection, Mr. Speaker, the grant of bail is often accompanied by the requirement of persons to act as sureties or guarantors that the person be released will appear. The person may be required to report to the police station at specific times. The person's passport may be held if the person is seen as a flight risk, and of course, if the court feels that a complainant or a witness's safety might be in jeopardy, bail may be refused. This is a balancing act that is usually undertaken by the court. At all material times, though, the competing interests of all persons, the accused, victims, witnesses, and others in the general public, all of these competing interests involved must be taken into account by the court. The court has to give consideration to the requirements set out in Section 4 of our Bail Act, including circumstances such as A, where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would fail to surrender to custody, or may commit an offense while on bail, or interfere with witnesses, or otherwise obstruct the course of justice, whether in relation to himself or any other person. The court would also want to consider and has to be satisfied that the defendant should be kept in custody for his or her own protection, or where he or she is a child or a young person, for his own welfare. Where he or she is in custody in pursuance of the sentence of the court or any authority acting on the St. Christopher Nevis Defense Force Act, Cap 19.14. Another consideration would be where the court is satisfied that it has not been practicable to obtain sufficient information for the purpose of taking the decisions required under this section, and for want of time since the institution of proceedings against him or her, to gather further evidence and information. Where, for instance, having been released on bail in or in connection with the proceedings of a particular offense, he or she is arrested in pursuance of Section 12 of the Bail Act. And Section 12 of the Bail Act, Mr. Speaker, would involve some of these other things, where, for instance, someone may abscond, or such conditions as the surrendering of a passport to the court, wants to leave the state, and those other things, does not appear or report to the police at the time specified, if there's a breach of the conditions, generally. Again, the court may want where he or she is charged with an offense, or is an alleged offense to have been committed, then goes on, commits another offense when they are on bail, when he or she was released on bail, where his or her case is adjourned for inquiries or report that it appears to the court that would be impracticable to complete the inquiries or make the report. Mr. Speaker, the prevention and reduction of crime and criminality is a complex and multifaceted issue. In seeking to bolster the law, for a more efficacious, for a better legislative framework in relation to bail, government experts have reviewed the current system and made certain policy proposals, including those reflected in the current bill. However, it is clear this work on our legislative framework must continue, and it is anticipated that laws such as those for bail and for firearms offenses would continue to require periodic review. In that vein, consultation on the bail amendment bill and also the firearms amendment that was done a couple of weeks ago has continued since the time of their first reading. In light of these consultations, the bail amendment bill will be adjusted, as I mentioned earlier, when it comes to, from the bill that was circulated the first reading, when it comes to committee stage, to reflect the further thinking on the matter. And with each stride, we hope to build upon the existing laws in such a way as to afford better protection for our people. The original recommendation by the police was for the burden of proof to be shifted to the defendant, and this was reflected in the original version of the bill. This approach has been taken in a number of jurisdictions, especially in relation to such offenses as for terrorism offenses. However, after due consideration, the preferred approach was to leave the burden on the state, but to increase the standard of proof. In other words, the court must be satisfied beyond a reasonable doubt, and the public and witnesses, reasonable doubt that if the defendant is to be released, he would comply with the conditions of bail, and the public and witnesses would be safe. We have seen too much of a trend over the last 5 years that people who are released on bail, especially when it comes to firearms offenses, were alleged to have gone and reoffended while on bail. And part of our attempt to strengthen this act, this bill, is so that the court will have to take those types of things into consideration. The modification of the Bail Amendment Act would entail the replacement, Mr. Speaker, of the proposed new Section 3, Subsection 3. The modified Subsection 3 would now provide for the following: where a person shall not be admitted to bail if that person is charged simultaneously with murder, under the Offences Against the Person Act or any other law in St. Christopher and Nevis, and B, an offence under the Firearms Act, except where there is evidence beyond a reasonable doubt that the defendant will comply with the conditions of bail. The second modification that will be applied to this bill is that in subsection 5, this would provide the following. Where a defendant was convicted of a criminal offense under the Firearms Act, and a period of 10 years has not yet elapsed, and that defendant is again charged with any offense under the Firearms Act, bail may only be granted where there's evidence beyond a reasonable doubt that the defendant would comply with the conditions of bail. And Mr. Speaker, additionally, a new provision would be inserted in relation to the use of monitoring devices or ankle bracelets as a condition of bail. These ankle bracelets or these monitoring devices would contain electronic implements so they can be read so as for the police and security forces to identify where those people who are on bail, who the court has requested that they wear an ankle bracelet, such a monitoring devices can be monitored 24/7. We believe that, and it's anticipated, that this measure would increase the effectiveness of police monitoring of persons out on bail. It is intended that the bill would also be adjusted by adding a modification to the first schedule of the existing Bail Act. In that schedule, all offenses which would require a bail application to be made to the High Court, in the High Court, are specified. There are some 4 of them. The proposed modification would add to that list of offenses. Currently, the schedule provides that the bail application would be heard in the High Court for murder, for treason, for hijacking, and other offenses for which death is a penalty fixed by law. In that connection, it is now proposed that firearms offenses, contrary to the provisions of the Firearms Act and Section 4, Subsection 5 of the Bail Act, would also be heard in the High Court. Additionally, manslaughter under the Offences Against the Person Act, not the Vehicular and Road Traffic Act, would now be heard at the High Court. Applications for bail for terrorism and for sexual offenses would also have to be made in the High Court. Mr. Speaker, the bill is intended to fortify the current prevention strategy, and if enacted, it should form an important part in the ongoing fight against crime. The bill is intended, therefore, to ensure that dangerous criminals who are likely to reoffend would be treated appropriately. Mr. Speaker, you will recall that the Constitution clearly outlines and supports the observance of due process of law for persons who have been accused of breaking the law. Section 10 of our Constitution, for instance, Mr. Speaker, guarantees the presumption of innocence. And in Section 5, we see where someone should be brought to the court within a specified time and should not be unduly detained. They have, as it was, this fundamental right to liberty, except where there is an order of the court. But, Mr. Speaker, this recognition of the protection of law to an accused also stands for all other citizens who are well-minded. Law-abiding citizens as well must be protected under our Constitution. And that is one of the hallmarks of our system, our particular system of government in the Federation. And so, Mr. Speaker, the provisions of the Constitution make it very clear that the enjoyment of rights and freedoms by any one person should not impair the rights of others or of the public interest as a whole. Undoubtedly, Mr. Speaker, there's a deliberate, a delicate balancing act that must be undertaken, taking into account the constitutional rights and responsibilities, as I said, of all persons in society. And every step must be taken whilst being fully cognizant of the rights of everybody in our society under the protection of the law. Mr. Speaker, as you're aware, the nature of good governance dictates a reasoned and a measured approach to the administration of justice. We are fully cognizant of the merits of respecting the liberty of an accused who is cloaked in the robe of innocence until he is proven guilty. But as you are equally aware, Mr. Speaker, the events of the past number of weeks and months and years that have resulted in violent deaths of several of our citizens mandate that we take special notice. They meditate, they suggest to us, they implore on us that this has been an attack on the overall liberty of all our citizens as a whole, and has brought us to this point about crime, with this debate a couple of weeks ago. And again, this bill to amend the Bail Act today needs to be taken exceptionally seriously. Mr. Speaker, the courts have also had to grapple with this debate, and we have considered the various positions that have been articulated in a number of judgments at the court as well. But we represent the people, we represent, as it was, the making of the law, and we'd hope that the court would interpret them appropriately as we would hope that, as we would intend. It is in recognition of the need to address the administration of justice in a holistic way that an additional court has been set up, and we are working assiduously towards the introduction of a system of paper committals, sufficiency hearings, ultimately doing away of the preliminary inquiries, the PIs, that can take so long and slow down the whole process. Mr. Speaker, the rationale behind the introduction of these kinds of measures is to facilitate the processing of matters in a more quick manner so that persons accused might be brought before the court expeditiously for trial. We require that we get a system in place that now produces more speedy trials. And so the question of bail, where somebody should come to trial, but if it is felt, if the case can be made by our security forces, that someone can be a danger to our public, we believe that once the court is satisfied to deny bail in those circumstances, that we would still be able to give that person a speedy trial, a hearing before the court in a quick manner, and not to violate any of their individual rights. In a situation, therefore, where a person may be refused bail because he is unable to satisfy the court that he would conform to any particular conditions of bail, or that he would pose a significant threat to the peace and order of the land, then the objective is to bring that person before the court as soon as is practicable to have this matter dealt with. Mr. Speaker, we are a country founded on the rule of law, and we therefore believe that all our people are entitled to the protection of their fundamental rights and freedoms. We also believe that our people have a heartfelt desire for the preservation and protection on the climate of economic well-being, where there is peace and good governance and security in our land, and in the context of respect for law and order. And so, Mr. Speaker, I would hope that we get the support of all our members in this measure to enhance the tools that we need to fight and to enhance our criminal justice system. And I would wish this bill safe passage to this honorable House. May it please you, Mr. Speaker.
Stay up to date with news, programs, and activities of the government with SKNIS. Like us on Facebook. Listen to us on SoundCloud. Follow us on Twitter. And watch our videos on YouTube. Connect with us today. SKNIS, St. Kitts and Nevis Information Service.